Hi, I'm Will Lewis, and we're back for Season 3, Episode 6 of The Art of Outsmarting with Keith Mitnik. Our topic today is going to be the language of the case, in particular in regards to opening statements. For anyone who's followed Keith in the past, they know how much time and effort and importance he puts on getting the right language, getting the right phrasing, and keeping those themes throughout the case. So I'm excited today to talk about that with Keith.
Personal injury cases hinge on the details. ABC Legal, America's most trusted process server, simplifies every aspect of service, so you can focus on winning your clients' cases. ABC Legal-empowered process servers deliver documents nationwide and make 12 million attempts annually, with real-time GPS-tracked updates and proof available online. ABC Legal's simple and transparent services make life easy for your team and help you keep costs under control. Your clients deserve consistent, reliable, and accountable service of process. Sign up for a free account today.
So, Keith, I guess let's start, and I just mentioned it. I know you value heavily the getting the right phrases and keeping those phrases as a theme throughout the case. Can you talk a little bit about why you think that's so important?
Yeah, I've just spent, I've been doing this for 40 years, and I've spent so much time in the courtroom. I realize I listen to other people, and they'll use one word, and I cringe, and if it's our lawyer, and I don't like it, and I'm not talking. And I hear another word, and I go, that's it. I hear the other side, the defense, use a word, and I go, well, that was a mistake for them. And they use another phrase to make the same point. I go, oh, boy, that hurt. So I've just had that reaction for so long. I know, not intuitively, as a matter of fact, the power of picking the right words. The impact on the listener is, I'll give you an example. Here's one I'm on a tear about. When I hear of one of our lawyers get up and ask our client, say, tell me what you can't do, I want to cry or choke them. Because unless they're in a wheelchair, I don't care. You can say you can't walk anymore. That's good. But when you've got a herniated disc and they're walking in the courtroom, the jurors seeing them, they're walking out of the courtroom, there's surveillance, watching them use a weed whacker. And you start talking about, I can't, it's just loose talk. It's not a lie, but you know what it sounds like? Exaggerating. And do you ever want to step into exactly what the other side's accusing you of? Exaggerate, overstate. All you got to do is, so what's the right word? Rather than say, tell us what you can't do. Tell us what you don't do anymore. Or tell us what you do less of. Or tell us what you do differently. Now it's accurate. It's simple. But I tell our lawyers, you ought to consider the word can't as a dirty word. Like you wouldn't stand up in court and say F-U-C-K. Just saying it makes you nervous. Think of it like F-U-C-K.
Yep.
And get it out of your vocabulary. Now, that's an extreme example. It's like accidents. Accidents happen. This is an old one everybody knows, but say crash, say collision. That sounds like it would hurt you. So those are classic examples. Well, one's classic, the other's, a lot of people don't think about it because they're just saying you can't do it and they mean you don't do it. Don't. Once, it ain't the end of the world. 30 times, you start sounding like you're exaggerating.
I'm not at the workup phase anymore, but I face it in court, and it happened in the workup phase. And that is your client who has gone too far. They have been baited into going too far in depo because extremists, like defense lawyers, love extremes. And nothing they like better than is for your client to overstate their health before the crash. Because that's going too far, and that creates a big opening in our case for them to run through. And we are constantly trying to stop it. Why do our clients do it? Are some of them bald-faced liars? I'm sure. But I think that is by far the minority. I think the vast majority is one of a couple things. They're loose talking. They say things like I can't when they mean I don't, because that's how we talk. I can't run anymore. If you said, Mitnik, when you go on the beach, why are you walking? Why don't you run? I say, I really can't run anymore. It's bullshit. 6 months ago, I decided I was going to run. I got by it for about 2 weeks. Like, my God, I can run. Man, I found out I can't run anymore. And my back woke up one morning, I couldn't sleep. I'm like, God damn it. I don't run. It's not worth it. I walk. I'm 65. It's not that I can't. So clients lose talk, say I can't when they ought to say I don't. They don't know better.
You know, obviously we've had the chance to talk about that particular issue in the past, and what I've now incorporated that into my deposition prep, because that's one of those lessons where, yes, it applies in the courtroom. It really applies a lot in the pretrial issues. You know, when you to make sure your client they're not lying when they say I can't, I can't carry a jug of milk anymore because of, whatever happened to my neck or my arm, but they really mean they don't. If there was a gun to their head, would they? Sure. And if you can take that can't out of their vocabulary in the depositions, it takes a lot of the ammunition away from the defense at trial. That's something I learned from you that I think, obviously not all of our cases go to trial. That lesson is really applicable in almost all of our cases, unless, like you said, you have a true can't situation, wheelchair, something like that. Another thing that I know from working with you is you spend a lot of time on this. Could you kind of tell the audience, that this isn't something that you show up, the day of trial and say, these are the words I'm going to use, but you actually prepare. Can you kind of talk about that preparation and how you come to the point where you find the right words for the particular case?
Some of it for me is because I'm just so attuned to it. I hear myself use the wrong word and I immediately catch it. But that's come from this process, which anyone can do. You can be right out of law school and start the process. Thesauruses. You say thesaurus, and you might as well be saying Christmas morning to me. If I get a word, I will be preparing, and I got a word, and I go, nah, there's a better word. But I don't want to break the flow I'm in the middle of. I just put a little TH and put in parentheses. I know it means come back, play with the thesaurus. From that point to the end of whatever I'm working on in that draft, I'm excited because I know I get to go back and play with my thesaurus. So and here's what you learn. When you start using thesauruses, it's not as simple as a different word, because a thesaurus will take you to another word that really, there's an overlap, but there's another concept of a really different definition, different meaning. Not just, here's 3 ways to say something means this. There's a slightly different meaning, and there's 8 words to that meaning, and you realize, I've just switched a little bit different meaning, and I actually got closer to what I'm trying to say. Not just a better word to say that. I realized what I was trying to say, I was off the mark a little. So now I'm in a little different meaning. Now I get to look for the words. So I've got probably 8 hard thesauruses at my house. I've got more apps than I know what to do with them. But I've zeroed it down to, I'm going to save you a lot of time and money. Don't buy a bunch of thesauruses. The ultimate one, if you want to, I love the Oxford English Dictionary, and it's like $250 a year, and you're a member, and they have this historical thesaurus. This is great. It's a little complicated to use, but if I'm really playing around and I'm having a hard time, I go there. 99% of the time, I got 2 apps. If I have my iPad, I have something called WordFlex, and it's amazing. It brings a word up, and it spirals out all the different potential meanings and all the words around that. And it grows into this almost viral thing on your screen. And you look at it, and then some of them you can click and it'll take you to brand new word screen. That's the best of the best, other than Oxford English Dictionary. But I don't carry my iPad all the time, and I can be sitting on an elevator thinking, what's that word I want to look? I've got, this is on your iPhone, because WordFlex only works on an iPad. You can't get it on your phone. Get Word Hippo. HIPPO. It's got this little pink fat hippo. Word Hippo. Easy to remember. I don't know why it's so much simpler and better and more detailed, but it's better. I got all these apps on my phone. I probably ought to just pull them off from the source. Word Hippo is fantastic.
Well, I think something that's of value to our listeners, I know has been of value to me in the past, is getting some examples, because a number of these themes that you have in phrasing you have is applicable to a lot of cases. It's not just particular to this single issue in this particular case. So I was hoping we could talk about some of those today. And I know, I know you kind of break this down into phrases, adages, analogies. I guess let's start with the catchy phrases.
Sure.
What are some catchy phrases that you've kind of crafted over the years that our audience would find useful in their cases that they see on a regular basis?
I do this in every case, and I do a lot of unique cases, and it's fun for me because now it's a whole new slate to find the right words and phrases and adages to work with. But I'd rather talk, when we do this with everybody listening, I can give you some words to show you how to do it, and I'll be all excited telling you, let me tell you the word I got in this case, but this case you're probably never going to try again or use the word again. So out of respect for the people's time who are listening, I like to focus on things that are going to come up a lot, because some of these words and phrases, you don't have to go reinvent the wheel. It's already there. I've done it. They work good. Why not take them? So I want to share the concept for when you need a new word, phrase, and adage, but I also want to share some of them that are already baked into the cake. So I like to use your typical car crash case with herniations, because most lawyers do them, and we do them a lot. And so there's a lot of overlap between them. One of the classic examples is that I came up with years ago, and a lot of times I come up with things and they evolve and they change and they get better. This one's, I don't think you can improve on it. And then that's pilot light pain. Where did it come from to start with? I'm sitting in a courtroom realizing that my client doesn't look hurt. And they're getting a lot of mileage out of they don't look hurt, whether it's surveillance or just sitting in the courtroom. People are going, gosh, you're talking about all this money and they sure don't look that hurt to me. It doesn't look, if you was a big case like you're talking about, you'd look a lot worse. And I thought, I got to deal with that head on. It's a reality. It's not fair, but it's a natural reaction. And with an unbiased juror, I can take that unfair, natural conclusion and get them to a fair, correct conclusion. And one of the ways to redirect them is these words, phrases, and things. So a catchphrase that I use is, it's not pilot light pain. Now, I had a lawyer, smart lawyer in the audience tell me, but aren't you worried younger jurors won't know what a pilot light is? And I thought, ah, damn it, he's right. I'm showing my age, because who the heck's got a stove or a hot water heater with a pilot light anymore? And then I thought, so I started abandoning it, and I thought, it's too good, I can't do it. And I realized all I got to do is teach the younger ones what it means. And they're a little fascinated. It probably adds to the power of it. So I'll, in opening statements, say, you're going to hear. And I like to use the phrase, you're going to hear. It's better than the evidence is going to show. But as soon as the judge and the defense lawyer hears you're going to hear, they think, here comes the evidence. So it kind of gives you a little latitude to talk in something might otherwise draw an objection as argumentative in opening, even though it's not argumentative. But I say, you're going to hear this kind of pain, my clients, God is often referred to as pilot light pain. The reason is, any of us that are old enough know what a pilot light was. The old hot water heaters or the stoves had a little teensy flame that just flickered. And when you needed the heat, you turned the dial and it would flare up. When you turned it off, that pilot light never went out. It was still there flickering. Every now and then something would happen to blow it out, and you'd have to take one of these long matches and relight it. But it was intended to always be there flickering. And when you needed it, you just got more gas and it would flare up and it would heat the hell out of the water. That's pilot light pain. So I explained that without the hell to the jury, and now we're all on the same page what a pilot light is. And then you can explain, now, the reason it's called pilot light pain is it's always there flickering. It never goes out. So on my clients' best days, there's some level of that pain's there flickering. And the more activities they do, the more it flares. So my client lives between flickering and flaring, but it's always there. That's why we call it pilot light pain. So that's a classic example of using it's kind of a hybrid. I consider it a catchy phrase, but it's a little bit of an analogy too. So it's kind of somewhere in between. So pilot light pain's one. Another one is the flaring. Now you've got that into your case, and you can talk about what are the things that cause your pain to flare or spike. Those are good words. Everyone knows what flare is. Everyone knows what spike is. Heck, you can even take create a diagram that looks like an EKG and say, here's what causes it to spike up. And now you got all these little spikes during the day, which leads to another catchy phrase. Because my client lives in pain now, I'm going to pause a minute, in pain instead of with pain. Here's the power of words. Say you live with. What do you think? Live with it. What do you think? Get over it.
You're dealing with it. Yeah.
Get over it. Quit your whining. Live with it. If you say live in, now you feel saturated. You're steeped in it. You can't get it off of you. So my client lives in pain now.
That's great, because you can think they're like they're trapped in it.
Yep.
They weren't in it before, and now they're in this box of pain they have to live with, for the rest of their life. That's
so
great.
Where'd I get that from? I'd used it in a courtroom. I said probably 10 times. My clients, now living with pain. And I sat down and went, that just felt lousy. And I couldn't figure out why. And it wasn't until after the trial I thought, what was it I didn't like? And I had to go back and remember. And I went, with. I'm going to live with it. Just means get over it. And I thought, what's a better way to say it? And I thought, living in pain. And now, every now and then, I'll still in front of a jury slip and go live with it. I immediately catch myself and change it. Because who cares? No one's paying that much attention. The repetitiveness, it starts having an impact on the listener. So my client lives in pain as a result of it. My client now, here's a new good phrase, now has to make many choices, do or don't do, knowing either way they're going to pay a price. My client has lost the freedom. Now, this works on all jurors, whether they're Trump jurors or don't like Trump. Everybody understands freedoms, and you shouldn't have your freedoms taken. So, as a result of this living in pain, my client's freedom to live life without making all these many choices has been taken. So it isn't that my client can't do, here we go, we're not going to use can't. It isn't that my client can't do things. It's that my client knows if he does these things, there's going to be a price to pay, one way or the other. Do it, spike in pain, flare in pain. Don't do it, now we're back to pilot light pain. But guess what? They've already paid the price by not doing what they would have otherwise done. So my client now has had the freedom to live life without having to make all these many choices, do or don't do, knowing there's a price to pay either way. And that's now their life. Why is it their life? Now that it's their life, what does that mean? It means it's now autopilot. They've actually converted they make those choices without even thinking consciously anymore. Now I'm going to roll into another catchy phrase. It's now their new baseline. Their baseline used to be up here. When their baseline was up here, they just kind of did what you wanted to do. You wasn't thinking, what's the price to pay? Am I going to get a flare up, or I want to do it? I want to do it bad enough. I'll just deal with it. I'm going to have the flare up. I'm not just giving them surrendering, or I just don't want to deal with it now. I got enough going on, so I'm not going to do it. So they're making those choices. That's the new baseline. The old baseline was up here. I just do. Now I'm making choices. So what does it mean for the rest of their life to have a baseline that used to be here that's here?
Baseline reserves coping. She's got that thing in her spine already. If someone was in perfect health, this works with someone overweight, this works with someone with a condition like this works, maybe smoking, I don't want to go too far trying to exploit the smoking, but whatever it is, they got problems. They got pre-existing crashes, injuries, they got aging, whatever it is, health problems, they weigh up 400 pounds, whatever it is. When someone's baseline is way up here, they have a lot in reserve, which means they have an ability to cope better when something comes along like an injury like this that gets thrust into their life. And the fallout from it is going to be less to them because they got a lot in reserve to help them cope. But when someone already has this kind of problem in their back, and they got a weight problem, on top of that, she's got a nicotine problem. Her baseline's already down to here before this ever happened. So you know what that means? She's got a lot less in reserve for her to cope with the fallout from this. So the fallout to her, I wouldn't put cigarettes in, because as soon as I say the fallout to her, they're gonna say, then quit smoking. So don't put it in there. It diminishes the power of this. She's got the back thing or whatever else. She's already here. She's got less in reserve to cope with the fallout of this. And they want to tell you she has this in her back. I say, yes, she does. And she's the last person in the world needed that thrust into her life unnaturally by no fault of her own, on top of what she already had. It's not like a addition problem, it's a multiplication problem. It compounds. So the fallout and the impact to her has been greater than someone else who had otherwise in that area was in perfect health. And so now you take that they're trying to exploit against you because they're going too damn far, and it's going to create an opportunity for you to run through by pointing out baselines, reserves, coping.
Keep it in mind. Here's another phrase. This is a verdict for all time. This isn't going away. That is the new baseline forever.
Now my client's 40. It isn't supposed to be going on now. And this is a verdict for all time. What's going to happen when the natural aging process overlays on top of the damage in his brain? Headaches. What would someone do to avoid a headache? Now, I'm not suggesting my client never had a headache in his life. Of course he did. There's a difference between a headache and living with headaches. People do live with them, no one's fault. But someone that wasn't living with it, and it was thrust into their life by no fault of their own, unnaturally, and now they're living with it as a routine part of their life.
Here's another phrase, forever injury. And you start seeing how these things string together. And when you string them right, because you've thought about them, you played with the thesaurus, you've thought what ring didn't, your awareness. First thing is to create an awareness for how things sound that are repetitive words. And what is the image I'm creating long term? Because remember, at the end of the day, what's this whole season about? Being difference makers. How are we difference makers? We can't change facts. We can change conclusions from facts. How do we change conclusions from facts? We have this toolbox. Right now, we're talking about creating the language of your case because you want the jury to conclude you're not whining, this is profound, but you're making the most of it, but it's changed your life forever in a significant way, although you can't see it looking at it, which leads to another phrase, can't judge a book by its cover.
It's interesting, from listening to this and having seen you weave these together in all of this, for our audience, you're bringing out kind of all of these words, all of this framing in opening statement, right? Because, you think about what you just did there. You started to talk about pilot light paint, then move into the many choices, freedom, which is then taken. I know taken's a big word for you that you use to describe the injuries. And then you went, right into that affects their baseline, and that doesn't change all time forever. And I've seen you weave these in an opening, and it really is effective. And what I think maybe separates you, and I think our audience, one of the things we can learn from is that these words aren't by accident. Specifically as a taken. What was I'm trying to remember what was the word you heard a lot instead of taken, or how did you hear pain described and the impact of injury described before you kind of came up with something being taken?
I'm going to give you another catchy phrase that led to taken. It actually came first. It was a two-step process. I realized I got jurors. Many of them are sitting on those chairs, and during jury selection, we're sitting in them sorry benches, uncomfortable, because they got aches and pains. And guess what didn't happen to the vast majority of them? No one gave them a cent. So you got a bunch of people saying, well, I'm in pain. What's it? We all got pain. No one gave me money. Get a grip. I'm here for pain? You mean I got to spend a week here because someone's whining about pain? And I'm sitting there, my ass is on fire. sitting in this damn thing. And I thought, that's a reality you can't put your head in the sand to. So I started thinking, I got to distinguish their pain. If someone say got chronic pain on your jury, I thought I can't have them. But I thought, what a great juror, because they get it. And I realized I can keep them so long as they're not biased, and they could really be better if I could make one point. This was thrust into her life unnaturally by no fault of her own. One day she didn't have it, the next she had it, going to have it forever because someone wasn't driving safe out on the road that day, endangering the motoring public, and thrust this into Miss Jones' life by no fault of her own forever. Now that juror goes, well, you know what? If I didn't have this and all of a sudden I had some jackass hit me, you better back up a Brinks truck.
You know, and I love how you distinguish naturally, because most of those people in that audience, they developed from playing football over the years or whatever. Or is happens to,
got drunk and fell out of bed or something.
Sure. That's how you were able to distinguish those kind of natural ways that people, wind up with back pain or neck pain from this being unnatural. I think that's very effective and unique. You don't and succinct too. That's the other thing about these words is they say a lot with one or two words, with just a small phrase.
You just said, well, I love trying the case with you because you get it. You see why we're doing what we're doing, which is you're communicating so much nuclear. The fewer words you have to say, but the point's made. And then when it becomes repetitive, it sticks. And now you got jurors go back in the deliberation and they start talking about pilot pain. And someone says, well, my back hurt. You say, yeah, but it was when it wasn't thrust into your life. You've given them words sticky, meaning they can repeat them. They stick. And when they can repeat them, now the good jurors can speak on your behalf in closing argument because you taught them the language of your case. And you see the power of doing it. You want to educate the jury, but you got to do it like this because of attention spans and your time limits in court. So you have to be mindful of how can I most powerfully get across what I want to get across as succinctly as humanly possible. In these words, phrases, adages get there. Now, an analogy is extraordinarily powerful.
Creating the language of your case. If you're going to do packaging in the most powerful way, you have to pick the most powerful words for the package to communicate the conclusion you want it to communicate. Every word comes off our tongue, worry about it, or we'd be tongue-tied. But there are certain words that are going to stake out and define who's going to win the battle over conclusions, over the facts that are fixed. And those better be the right words, and it's worth your time to figure out what are the most powerful words that are unassailable. And I say unassailable because I can't tell how many times I've thought of a word and then I thought, God, that's going to backfire. I cannot tell you how many times I've beaten the stew out of the defense for picking a dumb word. It sounded good until I showed them how bad it was. And I don't want them to do it to me. And I've seen it done to plaintiffs' lawyers before. And I probably younger, I don't remember it because I try to forget the worst of the worst. But I've probably done it. But I don't do it anymore because if it's going to be one of my power words, it's going to be vetted through my brain out one side and the other, and I may talk to 20 people about it because whatever the word, the phrases are, the analogies that I pick, they're going to be perfect because they're too important because it is at the heart of the right conclusion versus the wrong conclusion. How we talk about them is everything about how the jury concludes from them. A wrong analogy, when the lawyer gets up and says, he's right about that analogy. Let me tell you why. Boom, and you're going, it's fun to do it to them. It's no fun having it done to you. So think about it.
Well, I could talk all day about analogies, but the reason, there's science behind analogies. There's a reason analogies work so well. Human beings, and I got this from some book that was written by some Harvard professor, and he was a neuro-linguistic something. There were some of his titles I'd never even heard of. And I saw him Barnes and Nobles. It's like Stuff of the Mind or something. And I thought, oh my God, I got to read this. And it was god-awful over my head. But I found something in the middle was worth this 400 page, and I read every damn page of it. Spent a lot of time looking words up it, you know what they meant. But there was a little section in the middle that changed a lot. It was analogies, and that section was human beings cannot perceive or fathom or truly appreciate some other experience for which they have no personal experience. We just bury your mind. So how do people expand their understanding without having to do everything? Analogies. It's the only way. That's why if you listen to people, you will hear them walking on the street. Give yourself 24 hours and pay attention to how many times you hear people say it's like, which means here comes an analogy. We intuitively do it because it's how we communicate an experience to someone who hasn't had it. And we know it from caveman days. Literally, the guy went through this whole history. And I thought, now there's something. But instead of doing it intuitively, I'm going to do it as a trial strategy. And the way it works is you didn't understand that experience. And I can use all the adjectives in the world. You're never going to really appreciate it unless I say it's like, and it's something you have done. Now you've expanded your knowledge because you had that experience and you said it's like this. And now you go, I really am stepping in your shoes and I get it. And what is the real power in the quorum? The one thing we would kill to be able to do is the golden rule. Analogy is by its nature is a lawful, permissible way to golden rule. Because how are they connecting? It's like, and they've had the experience. But there's no one can object because everyone in the courtroom, including the judge, is going to use analogies. So that's the power. So here's an analogy. How do I get across? First of all, you ask the question. I'm going to go into the analogy. You ask the question just to finish the circle. Where did the thrust into your life came from? And that where did I said it was 2 steps. It started with thrust into life, and then it went into taking freedoms. I was trying a case in an ultra-conservative area up in Mississippi. And I thought, I've got to activate some of that conservatism to my favor. And I thought, thrust into your life, and I thought, but what's the impact? Taking freedoms. And they're going to appreciate that. And so I thought, how can I talk to these people so they understand the real horrible impact of living in pain? And I thought, it takes people's freedoms to live life. And I thought, that's the language. I thought, but freedom to what? They're not being locked up. And I thought, freedom to live life without having to make all these many choices. So that's where it came from. Coming back to the analogy, that fits into the thrust into your life. I've got the jurors sitting there in pain. And I thought, or I got the jurors not sitting there in pain. I thought, but everybody has had pain. How can I harness the awfulness of being in pain? And I thought, analogy, something everybody's experienced. And that's where it's like. Someone sleeps wrong. They wake up with a crick in their neck. They get up in the morning and groan. Their wife says, what's wrong, honey? He goes, I slept wrong, I got a crick in my neck. Oh, I'm sorry. And he blows it off, says, no big deal. Because it isn't a big deal. But that day, every little thing he does, see, as you go through the analogy, this is bringing to life what it is. In a way, everybody goes,
been there.
Analogy, been there. Every little thing they do, they go to get up, they go, they sit. They're working, they sit. Pretty soon they're out because they're uncomfortable sitting where they just sat there until it was lunchtime. They get up, they feel better. But after a while, being up hurts, so they sit again, so they're up and down. They go to pick up briefcase, whatever they're picking up. You just feel it. Go to drive home, and they go to change a lane and look in a blind spot. You go, naturally, you do it, you look in the mirror, and then you go better. There's that little catch all day long. They go home. How was your day? It's fine, but this crick in my neck I could do without. Oh, I'm so sorry. No big deal, because it's not a big deal. Wake up the next morning, groan again. Wife says, what's the matter? I was hoping to be gone. We're only on day 2. I was hoping to be gone. Now they're waking up, groaning, and aggravated is still there. Starting to take a toll. That day is all the same thing. Every little thing it's there. You know what they don't do? They don't call in sick. You know what else they don't do? They're not walking around going, nobody at work has a clue. It's not that kind of an injury. Now you understand why they're sitting. I'm not saying to this jury, but now they understand why they're sitting there and no one knows. Doesn't mean it's not there. But you know what? This day, day 2, now they come home. and they're cranky, start short with the kids. Wife says, what's the matter with you? Sorry, this thing's put me in a bad mood. It's just getting on my nerves. I've had enough. Wife says, maybe you better go to the doctor, because she's like, I don't want the cranking house. Guy goes, no, sorry. He straightens up and changes his mood. Goes to bed, wakes up day 3, wife's in brushing her teeth. She hears, hallelujah. And she goes, what? Startles her. It's gone. Well, that's what my client's dealing with, except there's no hallelujah ever. And it didn't come because he slept wrong. It came because someone wasn't paying attention on the road, driving dangerously, rammed him, thrust it into his life, and it's never going away because it's a forever injury. Now, you know what you just did? You harnessed all those experiences, and now no one's going, get a grip. They're all going, when that happened to me, if you're telling me that shit was never going away and someone did it to me, I understand why they're here in court.
It gets them to empathize in a way that I think that, because of whatever maybe the tort reform or marketing campaigns have been done in the past have, led jurors to be suspicious. It is able to counteract that by saying, hey, look, this person has had a very similar experience that you've had, except, like you're saying, unnaturally, no fault of their own, and not going away. And, I've seen that, again, very powerful way to show an injury that otherwise you can't see. There's no cast, there's no wheelchair, but it's there. And it affects them, and I guess that's something maybe we'll talk about in a later episode, how that affects them 24/7. I guess we're going to talk about closings probably in the next episode and get into how that crink in the neck is not just while they're at work. It's not just while they're home. It's also while they're sleeping, and the value of all.
And it's not just the physical pain. It's the mental side of it.
How it affects your relationships. That's a great part of that analogy is it makes you think, I'm not myself. I can't go and work out the way I was working out before, but I'm not the same person around my spouse or around my kids. And, and I think that show, nobody wants that. Nobody, everybody wants to think, oh, I wouldn't be that way. But then they think, well, you know what? That time when I did have that crink in my neck. My back did hurt for that month. I probably wasn't the same. I think it's a very... Or
if you were, it's because you were mentally forcing yourself to elevate your mood.
And you knew it was going to go away too. I think that, there's a light at the end of the tunnel. There's no light for this planet.
See, there's an analogy. Everybody knows it.
It's the law and the evidence plus those life experiences, beliefs, opinions that we call bias. Not bias in a hateful way, in a human nature way, because we all got it about some subjects. Does everybody understand what I'm talking about? Evidence plus reality. They go, yes. That's where it all started. Then just to finish it, I roll it into whether it's barbecue or pies or Merlot versus cabs or whatever we're talking about. See, I'm going to give you one more quick example. Now, I'm stopping and editorializing. I do this whole thing under 5 minutes. Doesn't take long when I'm not stopping and explaining it. But then I say I'm going to do one more quick analogy just because I think and I say this to settle the judge down so I don't get barked at for giving a second story. Say, because I find it moves things along quicker, Judge, and I find it's respectful to the jurors if you know why I'm asking what I'm asking. And now that makes the defense lawyer feel like a jackass if he objects. So I get to do my second story. And I say, so one more quick example. If we're having a competition, you see, had the best pies, and it was down to 2 pies, 1 apple and 1 cherry, and I was randomly picked out of the audience to be the judge. And it just so happens I'm not crazy about cherry pie. Does everyone agree the only right thing for me to do would be to reveal that to the contestants and let them decide? Because the one with cherry pie probably wants to know if I'm judging it, I'm not crazy about his pie before I take a bite. Everybody go, yeah. Does everyone agree, in addition to revealing it, the other right thing to do is to be honest with myself and not sugarcoat the potential impact it might have on me in spite of my best effort to lay it aside? Not that I'm going to take some wonderful succulent pie, happens to be filled with cherry, and a dried up sorry pie filled with apple and throw it over the filling. I wouldn't do that. But the closer it gets, the harder it is for me to separate it. Why? I got a bias against cherry pie. I don't hate them.
I got a little bias. I bite into it, my lip curls. I'm just wired that way. I can't help it. So does everyone agree the only right thing for me to do would, if asked, to be honest with myself and not sugarcoat the potential impact it might have on me in spite of my best effort? Yeah. So if I got asked, now I circle back to the thing about the prosecutor. I say, so if I got asked, could you base your decision solely, now this is for that damn judge in Georgia and all the others just like him. I say, so if I got asked, could you assure us you could base your decision solely on the evidence presented in the law given by the court? So what I say in this, I converted a little. If someone asked me, could I base my decision solely on the evidence of those pies and on the law of the contest, meaning the rules of the contest? My answer would be, of course I can, but it would be the evidence and the rules plus my bit of bias against cherry pie. By the way, now I'm using the word bit of bias. Trust me, when you start questioning the jurors, they'll say bit of bias, bit of bias, bit of bias. And it's a little harder to deny it when the juror uses the word bias. I used to think you can't get them to say bias. I got them saying bias within the first 30 seconds of actual questions. Because I got a bit of bias against cherry pie. Would anybody, if I acknowledged those things, think that that made me weak-minded or made me an unfair person? No. Does everyone think it was the only honorable right thing for me to acknowledge it if I got asked? Yes, because maybe I'm better off down the hall judging the ice cream. I pretty much like all the ice cream. Chuckle, chuckle. Then I roll into it. Well, this case has got nothing to do with anything as lighthearted as pies. This is a serious matter. This is a personal injury lawsuit. Some people don't like them. They don't believe in them. Got a bad taste in their mouth. Think everybody gets in any kind of crash, runs out and sues. They think they jump out of the car and roll around and pretend to be hurt. Whatever, you read something, maybe you've been sued, you've got a bad experience. For whatever reason, you have some feelings or distrust or dislike for personal injury lawsuits. How many of you feel? Then I start getting it. Then I get someone to tell me, yeah, in all honesty, I couldn't assure you my decision based solely on the evidence presented in the law because it may be that plus this bias I got against them. And after a little while, I drop bit and I just say bias. Yes. And no matter, you try to put it aside, but that's your best honest answer. Yes. How many of the rest of you feel like that? Boom. Well, half the room's gone for cause.
Like it, or it's probably that's an old adage. Old adages. Can't judge a book by its cover. You know why old adages work so powerfully? They come with built-in history and authenticity. Your grandmother, granddad, grandma told me. My parents said it. You say you can't judge a book by a cover. You say actions speak louder than words. You can pick any of them. Do you need to explain what the hell it means? Everybody knows. Do you have to explain why it really means what it says? It's not a joke. No, everyone goes, I know it, I trust it. Like that. Like you just said a little while ago. Quick, saves time. Old adages are powerful tools. Creating your own catchy phrases are powerful tools. They stick. Analogies allow the people to truly step into your client's shoes. So that's creating the language of your case. In opening statement, when it matters most.
We've all heard of eye for an eye justice. Someone did something to someone else, took their eye. We took the person that caused its eye. We don't do that anymore. It's considered barbaric today. But you know, the concept is alive and well today in this courtroom. Because while most people think eye for an eye justice meant punishment, it doesn't. And by the way, look it up. It doesn't. I came up with this idea and I thought, I'm not going to say if it's not true. I pray I'm right. I researched. Sure enough, it was right. Sometimes a just heart is coming from some greater power. And it was right. Look it up. Eye for an eye justice is not about punishment, so I can now say it to the jury without worry. It was about full and complete recognition of what was taken or lost. That was deemed to be so important, and there's no better way for someone to understand the full recognition. That's the phrase, full recognition, or recognizing fully the value of what was taken than to go take their eye. There's going to be no ambiguity left in how valuable it was. That's full recognition the old way. And that principle's alive and well. We don't want to go over there and tear their back up, but we do want you to fully recognize it, because that has independent importance in a just world, whatever era we're living in. You feel the authority of that? And it's a legitimate biblical reference. I usually don't say the Bible. It's probably my own upbringing, and I feel like I shouldn't be using that in court. And I also worry I may offend someone. Who needs to say in the Bible when you say eye for an eye justice? So eye for an eye justice. What I have done is I have given historical context, and I have authorized and elevated why it full, not partial, not discount recognition, full recognition. Because if you do partial recognition, you have lost the whole point of it. The whole purpose is lost because it has independent importance. And I never say this, what I'm really saying, it's not just the money, it's the recognition. How bad are they hurt? And if they're hurt bad, then this is right. And to come along and say, I agree, but enough's enough, we'll do less. Well, you've just done something less than biblical justice. I don't say it, but that's the point.
Because remember, all of the jury studies will tell you minds are made up after opening or maybe after a first witness. Remember something else. Guess who gets to go first, and you get to get the lay of the land. Don't ever waste the power of that by not creating the language of your case. But don't forget this. Who gets to talk last? They do. If you don't create the language of your case, both to empower your case, to put your best foot forward, you made a mistake, but you also create the language of your case so you don't step in the potholes. They're going to create a lot of potholes. If you don't take it away from them, they're going to come out of opening ahead, and you're probably going to lose your case. One of the biggest ways you keep them, you get out ahead, and you keep them from passing you when it's their turn in opening, is creating a language of your case that not only empowers your favorite facts, it destroys their favorite facts. I call it pre-acting. Don't wait to react. You're not going to get to just sit and talk to the jury again until closing. You better do it on the front end and opening. And one of the greatest ways to do it is to do it by creating a language of case.
What I did in the case of the delay onset of the radiculopathy, the radiating pain, the arm pain, was I came up with something, and I now use it in every herniated disc case, and that is a toothpaste tube. And I say you can have a cap on a toothpaste tube. You can throw it in a shave kit or whatever kind of kit, throw it in a suitcase and travel all over the country. Bags get squished, everything pushed. You're not going to zip open your little shave kit and find toothpaste all over because the cap's on. But if you take the cap off, take your bag around, you're going to open up with a mess. And it's not going to squirt out like a squirt gun that goes, it's going to ooze out. And the more times it gets roughed up, moved up, turned and pushed, a little more and a little more and a little more is going to squeeze out. That's the way a disc works. When you break that outer shell and create an opening, it's like taking the cap off a toothpaste. And it isn't fluid that squirts out like a squirt gun all at once. It's thick. That's what's inside the disc. But people are sitting, turning, twisting, torquing. Everything we're doing is putting bits of pressure, kind of like that toothpaste that's in a suitcase that's getting jostled around. And a little comes out, and a little more comes out, and a little more comes out. And here's the truth. The disc is here, and over here is the spinal column, and those big trunk nerves that come out are a good ways away. It's not a big space as in out here, because it's all a small confined space, but within that confined space, there's quite a bit of distance between those big trunk nerves sticking out and where the disc belongs. And when that stuff starts coming, it can take a year, 2, for it to reach where it's actually pushing. And until it touches and pushes, there will be regional pain like he had right in the area. It will not be arm pain. And that's what happened. And the doctor, I told that to the treating neurosurgeon. He said, I love it. I'm going to use that toothpaste. I said, is it accurate? He said, it's exactly what happened. So now, what did I do? I gave him a framework to explain that makes sense, education, and I did it in opening. And then they don't get any mileage out of it because it makes sense. But I don't know of any better way to, in my mind, explain the difference between opening and closing. We've all heard the big bad wolf story, and I'll do a shorter version in case you've heard it, in case you heard me talk about it. Opening statement is like the big bad wolf comes and huffs and puffs and I'll blow your house down, and the house made of straw is blown away, and the pig says, not by the hair of my chinny chin chin, and he all huff and all puff and he blows it down. And he runs down to the second house. And that house is made of sticks. And the same thing. Little piggy, let me in, or I'll huff and I'll puff and I'll blow your house down, not by the hair of my chinny chin chin. And he blows it down. And those 2 pigs now run down to the third house that's made of brick. And he says, I'll huff and I'll puff and I'll blow your house down. And they say, not by the hair of my chinny chin chin. And he blows and he blows and he blows and he can't blow the house down. Opening statement is building the brick house. Under this new construct here, it's building the house that also has turrets on it that we can fire at the defense or the wolf when he's trying to get in. So what's closing argument? What a lot of people don't know is if you read the real full story, is when the wolf can't blow it down isn't the end of the story. He climbs on the chimney and he tries to crawl down the chimney, and the little pigs have put a hot kettle on the fire, and when he comes in, falls in, they put the lid in and they cook the wolf. Closing argument is about cooking the wolf.
So this has been fun.
This has, and look, I'm looking forward because I know we're going to connect this to closing argument in the next episode. So thank you very much.
Yeah, thank you.
As I'm sure you could tell, I really enjoyed the conversation with Keith today about creating the language of your case, in particular as to opening statements. Opening statements, as Keith talked about, is the chance for us as plaintiffs to frame our case and to define the playing field that the defense will have to work from. Keith gave us the tools today and some really great examples that we can use in our cases to, as far as the right language and the right framing. He talked about analogies. He talked about adages. He talked about catchy phrases, things like mini choices, what is taken from our clients, not necessarily what they're trying to get through this case. Obviously, the crink in the neck analogy is very powerful. So what we're going to do here in our next episode coming up is talk about how we can carry that language throughout the case, use it in closing, and create these themes that ultimately will resonate with the jury, and that when they're deliberating, they'll be thinking of when they're thinking of our client and our case.